thank you everyone for joining us. It's great to see so many attendees. We now turn to the main event itself, which is the talk on return to workplace. We'll be covering things like reluctant returners, no jab, no job policies, and other general COVID-19 related issues. I'm very pleased to be able to hand over to Bob Fahy, a partner in our employment team who, ironically, almost had to miss this session due to recovering from his own bout of COVID. So, Bob, an expert in both these fields, I will hand over to you.
Thanks, Nick. Yes, and if I have a coughing fit partway through, please excuse me. It's the only symptom I've got left, I'm very pleased to say. Yeah, I've got a glass of water here, so hopefully I'll be fine. Can we move on to the first slide, please? As Nick has said, I'm going to cover the current government guidance around attending physical workplaces. I've realized when I was preparing for this, I do have a habit of talking about coming into the office, but of course, that's not the only place where employees are going to work. So I'm trying to use a more neutral term. So I'll look at the current government guidance relatively briefly, I hope. Then I'll talk about managing health and safety issues around people returning to work or not wishing to return to work, before exploring policies around mandatory vaccinations and the extent to which they're feasible. And then finally, we've got about half a dozen cases now that have some kind of COVID element to them, and I'll run through all of those with you, just as I think they're probably the best illustration of the kind of issues that come up and need to be dealt with. So if we move on to the next slide, please. Thank you. The government guidance, the Autumn and Winter Plan 2020, is of course the government's guidance for England, and Scotland, Wales and Northern Ireland have their own, they're each responsible for their own COVID rules. Now, we don't have any delegates from Scotland or Northern Ireland joining us today, but we do have 3 or 4, I believe, joining us from Wales, or at least listed to join from Wales. So I will try not to just make assumptions about just setting out the position in England. But in England, on the 19th of July, England moved to step 4 of the roadmap, at which point the government's aim was to reduce rules and instead provides advisory guidance on how businesses and individuals could help reduce the spread of the virus and mitigate the risk of resurgence. Employers then had to make their own decisions about how to manage COVID-19 risks in the workplace, having regard to their health and safety obligations and any updated government guidance. On the 14th of September, the government published the COVID-19 response autumn and winter plan, which sets out how it intends to address challenges that may be posed by COVID-19 over that period in England. Apologies, that is my front doorbell. I think I'm just gonna continue to ignore it for now. Yes, so the autumn and winter plan sets out what the government intends to do over the autumn and winter to try and ensure the NHS is not put under unsustainable pressure whilst opening up the economy. In Wales, NHS COVID passes are needed for entry to nightclubs, cinemas, theatres and concert halls and many other indoor and outdoor events. Face coverings are compulsory on public transport and in shops and hospitals, and employees are still required to work from home wherever possible. If we move to the next slide, dealing with Plan B, you'll see there that the official line from the UK government is that Plan B will only be implemented if the data suggests further measures are necessary to protect the NHS. And in England, there appears to be a strong reluctance to go beyond the potential measures mentioned on the slide, which themselves are essentially little more than moving England into line with Wales, Scotland and Northern Ireland. I'm sure you'll all have seen that a number of other countries in Europe are now introducing anti-COVID measures, including extending the use of vaccine passports, mandating masks and recommending that people work from home. And of course in Austria, that's just moved into a full national lockdown. Looking into my crystal ball at the moment, there doesn't really seem to be any appetite for the government in England, at least, to up its measures. But of course, we shall see what happens as we move closer to Christmas. Moving to the next slide, I just want to mention specifically the position with the clinically extremely vulnerable. Those of you who've had to deal with issues relating to this category of employee will probably remember that there were 3 ways in which an employee could be included within that group. Firstly, they could have a medical condition that was included in the shielding guidance, and that included, for instance, organ transplant recipients. Those are certain kinds of cancers, certain severe respiratory conditions, and you know, the list was quite extensive. Secondly, their GP or clinician could have them added to the shielded patients list if they had any specific concerns. And thirdly, the population risk assessment could identify them as being at high risk of serious illness if they caught COVID. And up until September of this year, we have had a number of pauses, stops and starts, and not entirely clear information from the government about the position of people with CEV, but with effect from the 14th of September, when the shielding guidance was updated, the shielding program ended, and the persons previously identified as clinically extremely vulnerable were told that they should essentially continue to follow the guidance contained in the Cabinet Office guidance about staying safe and helping prevent the spread of COVID, and also take advice from the healthcare professionals, but otherwise not to be treated any differently to other employees. Now, that's not to say that employees who were previously classed as CEV and were shielding should all have directly returned to the workplace on the 15th of September, the day after the announcement. A return to work after shielding essentially should follow a similar process to a return to work after a period of sickness. So you're likely to want to carry out a risk assessment in relation to the returning employee, consider the nature of their role and their workplace and their specific medical condition, and taking those factors into account, consider whether any adjustments may be required. We've certainly had a number of situations, number of scenarios where we've been advising our own clients that it may in fact be prudent for them to continue working from home arrangements in relation to certain of their employees who would be likely to be regarded as disabled within the meaning of the Equality Act, and treat that as an ongoing reasonable adjustment for the time being. But of course, those situations are always very fact specific, so you have to look at the particular circumstances in each case. One other issue that you may often be faced with in relation to previously shielding employees would be arguments from them that it is, excuse me, it is unsafe for them to return to the workplace in their particular circumstances, which hopefully takes us quite nicely on to the next slide, please. So I think I've been in practice as a qualified employment solicitor for coming up to 20 years now. And prior to COVID, I didn't have much recourse to sections 44 and 100 of the Employment Rights Act. I think, honestly, they rarely arose. But over the last 18 months or so, they've really come to the fore. Just to remind you, section 100 protects employees by providing that a dismissal is automatically unfair where the employee leaves, proposes to leave, or refuses to return to a workplace because they reasonably believe they are in serious and imminent danger and can't be reasonably be expected to avert it. Section 44 provides protection in a similar way in relation to actions short of dismissal that amounts to unlawful detriment. Neither right require any particular period of qualifying service. They're day one rights. And the order mentioned on the slide amends section 44 to provide that the protection extends not just to employees, but also to workers, and that they therefore have the right not to be subjected to detriment for raising health and safety concerns, leaving or refusing to return to an unsafe workplace, or taking appropriate steps to protect themselves where they reasonably believe they're in imminent or serious danger. There is a cut-off point for the implementation of the order, so the relevant act of detriment must have occurred on or after the 31st of May 2021 in order for the worker to qualify for protection. But certainly we have been seeing a number of circumstances where we've needed to advise clients on the implications of employees saying, in my circumstances, it is not safe for me to be at this workplace, and I'm not going in because of my fear about my health. And when we get to the cases, we can look at some examples of where employers have got that wrong and right. We move to the next slide, please. Hopefully there's nothing revolutionary or new in the list of practical steps to take to protect employees and workers from COVID risks, and also protect your organizations from legal risks. I've already mentioned risk assessments in the specific context of clinically extremely vulnerable employees returning to the workplace. Employers are, of course, also obliged to carry out general COVID risk assessments of their workplace and to consult over and implement necessary measures to mitigate health and safety. I would hope that you're not going to need me to go into a great deal of detail about the scope of an employer's duty to protect health and safety of employees from COVID risks. Those of you who are engaged in advising your employers, your organizations on these issues will have been well used to grappling with the practical realities for some time now. The government has published advice on managing health and safety and carrying out risk assessments. And they've published guidance for different kinds of workspaces. So there's ones for construction sites in respect of the construction industry. There's separate guidance for offices and so on. I've also mentioned on the slides some hopefully obvious precautions such as hygiene measures. For instance, in VWV's offices, we have an abundance of hand sanitizer around the offices, cleaning wipes for wiping down shared workstations before and after use by each person occupying them. One of the other points that you're encouraged to consider is ventilation, where that is possible. Of course, in many modern office settings, the position we have ourselves, opening window is not actually an option, where the entire building is sealed and ventilated through air conditioning. So it's not always an option open to you, but if it is, you're encouraged to consider it. I would expect, it's not on the slide, but I would expect you will look at appropriate social distancing measures as well. In our offices, we've had quite structured arrangements dealing with our return to the workplace since September. We started back at around 50% capacity. I believe most of our offices are now up at around the 75% mark. As Nick mentioned, I've recently recovered from a bout of COVID myself, and I strongly suspect that that was the result of traveling into or returning from the workspace. So there's obviously reason to see why some of your employees may be concerned about that issue, and we advise maintaining open dialogues with your workforce about the measures you're putting in place, emphasizing to them the steps you've done to help protect their safety, listen to their specific concerns and engage with them. And they may, those concerns may often be not just about being in a workplace, but they may be around how they get there and get home. So communication is incredibly important, I would say, in the management of workplace concerns around returning to the office or wherever else your place of work might be. Can we move to the next slide, please? As I say on the slide, it's no longer necessary for, it's thought, the government thinks that it's no longer necessary to instruct people to work from home, and is leaving employers to plan and implement their own return to workplaces. I do think that in many situations, an expectation has arisen among employees that having worked at home for so long, they've somehow accrued a right to do so permanently. Hopefully it goes without saying, but that's not the case. Contracts of employment will contain a specified place of work. Unless you've actually expressly agreed to permanent variation, working from home arrangements during the lockdown do not vary that contractual term. That there isn't an automatic right to work from home. Of course, employees do have the right to request working flexibly, which under the current regime requires at least 26 weeks continuous service, although the government is consulting currently about whether to remove that continuity of service requirement. These requests can cover a wide type of variety of requests. So That might be working from home full time. It might be partially working from home, partially working from the workplace. It might have to do with varying hours of work and so on. I suspect you'll probably be aware that it's an employer's duty to reasonably consider any such request and only to reject it on one of the 8 statutory grounds for doing so. Those include things like burdens of additional cost on accommodating the request, detrimental impacts on quality, performance, or ability to meet customer demand, an inability to reorganize work amongst your current employees or recruit new employees in order to share the work in accommodating the request. Practically speaking, my experience is that it's often not particularly difficult to find one of the 8 statutory reasons that may apply, but of course what you're obliged to do is consider the request properly and not simply have a knee-jerk response to reject it and then go searching for an excuse to do so. You should be applying the statutory grounds for rejection in a fair and reasonable way. And in addition to that obligation, where a request is made, for instance, as is often but not always the case, to fulfill childcare commitments, you'll also have to manage potential risks around indirect sex discrimination claims. In practical terms, like any other indirect discrimination issue, the risk management normally involves going through a thorough impact assessment exercise so that you can demonstrate you've properly considered what your organization's relevant legitimate aims are, and also the proportionality. You've properly considered the proportionality of refusing the request, weighing up the impact on the individual against the need to meet your legitimate aims, and therefore you're in a position to objectively justify your approach and the indirect discrimination claim can be defended. So I think that's pretty much everything I wanted to say about managing office returns. Obviously, if you've got any questions, pop them into the Q&A and we can do with them at the end. We'll turn now to employee vaccinations. Can we move on to the next slide, please? There's a fair amount of guidance around on vaccinations of workforces. The PHE's guide for employers is quite a useful set of resources. I encourage you to have a browse through the guidance and the various resources that it links through to. So there's a fairly wide list of documentation, Q&As, and guidance notes available within the guide. I've just listed there some of the basic recommendations that the guide makes around promoting vaccination, showing support through senior management, and indeed there's also a reference to appointing vaccination champions who can provide guidance and assistance to employees looking to get vaccinated. The guide also talks about engagement with community leaders, particularly in those communities where take-up of the vaccine has been proportionally lower, and you're probably aware there are a number of areas based on national or ethnic origin where vaccine uptake has been much lower. And the guide talks about providing support more generally to employees, and as I say, contains a number of resources. The ACAS guidance, again, is worth a look. I say this not by way of criticism, but it's very ACAS. So, and of course, ACAS has to deal with broad principles, and rather than getting into specifics, so it is set out at that high level that you often expect from their guides. But it talks about helping employers to consider, discuss, and introduce flexible ways of working, splitting time for employees between the workplace and remote working. It recommends consultation with staff or representatives around the introduction of flexible working patterns and practical considerations, regular communication, use of technology in performance management and health and safety. It talks about the benefits of creating a vaccine policy so that your employees can be aware of which roles are eligible, how requests can be made, principles such as the maximum number of days working remotely that the organization would normally expect, and circumstances in which you might devolve from from those limits. The guide also talks about hopefully obvious things, but ensuring staff are working remotely, who are working remotely aren't excluded and have access to the same opportunities as those in the workspace for things like training and development. Also ensuring that decisions are fair and transparent, and that other forms of flexible working are considered as alternatives to saying no. Considering training of line managers and staff on managing hybrid working arrangements, and exploring trial periods. As I say, that's a fairly quick summary. It is worth having a look at the guidance if you are actually looking at implementing either a vaccination policy or just dealing with requests for remote working or hybrid working. There's also some commentary from the EHRC. The only point I'd like to make about that is that inflexibility is likely to be what gets you. So creating and applying a blanket policy around not being permitted to work remotely is, as the guide points out, likely to be unlawful, probably some kind of discrimination, probably some kind of indirect discrimination that's likely to be difficult to objectively justify. So it really comes back to the point about engaging directly with employee concerns and engaging in dialogue, taking relevant factors into account and acting accordingly. So moving on to the next slide, we've had a few questions in the last 6 months or so about whether employees are allowed to ask employees about their vaccination status. I think the short answer is it is possible to do so, to ask whether employees are vaccinated, but you do need to tread carefully. Questions about vaccinations will amount to the processing of special category information for special category personal data for data protection purposes. So you will need to be able to explain your legitimate reason for wanting this information and consider how you store that information and by whom it can be accessed. The ICO's advice is that asking employees and allowing them to refuse to answer is more likely to be compliant for data protection purposes than any kind of mandatory policy. So if an employee doesn't want to tell you what their vaccination status is for whatever reason, you're likely to have difficulties in compelling them to do so. And in terms of certification, it doesn't appear to be something that's on the cards in England, although we'll see how matters develop. But I do see that a COVID pass looks likely to be introduced in Wales and possibly Scotland. It's not clear at the moment how that's necessarily going to operate in the workplace, though. But there will at least be some form of certification in those nations. If we move on to the next slide. Using that very Daily Mail phrase, no jab, no job. Compulsory vaccination policies for care home workers were introduced on the 11th of November. At present, that's the only place where compulsory vaccinations are mandated. There is a proposal to introduce an extension of compulsory vaccinations into frontline health and social care workers. That's currently going through consultation, but it's proposed to come in from the 1st of April of next year. In relation to care homes, it's maybe just worth mentioning briefly, I don't think we have many delegates, or perhaps no delegates currently with us from a care home organisation. So I'll just say quickly that it does apply to more than just the employees of the care home themselves. It applies to anyone who might be coming onto the premises to deliver services, but it doesn't apply to people who would be coming onto the coming near to the care home to deliver services, but not actually having to go inside. So, for instance, a self-employed hairdresser who went into the premises to cut people's hair would be covered by the compulsory vaccination requirement. A self-employed gardener who came in to cut the grass but didn't go inside wouldn't be covered. And there are exemptions on medical grounds, as you might expect. So we'll see how things progress into the frontline health and social care world, but at the moment, those are the only two current and proposed areas where compulsory vaccinations appear in a workforce. As far as mandatory vaccinations elsewhere is concerned, an outright requirement to be vaccinated, or if you don't get vaccinated, a threat of dismissal is unlikely to be lawful. I do think that it is important to distinguish between that very inflexible approach and applying some kind of policy requiring vaccination in order to visit a particular workspace or client's premises. The latter of which is, I think, you could say, is not necessarily going to fall foul of discrimination legislation automatically, but I think it's still a difficult proposition. And I've mentioned there the risks could include discrimination, constructive dismissal, or criminal offences of assault and battery. That last one, unless you're actually advising your organisations to, go around wielding syringes at their employees, it's probably not likely to arise as a practical risk. The more obvious difficulties would be, firstly, that introducing a new requirement like that would be effectively seeking to vary terms and conditions of employment, and therefore could create a situation where an employee may be able to argue that there's been a unilateral variation, a breach of the implied term, and that they can rely on that to resign and claim constructive unfair dismissal, as long as they've got the necessary 2 years continuous service, of course. Or there may be risks around discrimination, for instance, in relation to pregnancy. There may be it may be that a woman who is pregnant may say that it is legitimate for her to be more concerned than others about the implications of taking the COVID jab, although the information, the data, sorry, the word I was struggling to get there was data. The data from the US, where vaccinations of pregnant women has been taking place, appears to indicate that they are no less at risk than anyone else, and the advice to pregnant women not to be vaccinated has been lifted in the UK. So perhaps that is a risk that is now diminishing. You may get age discrimination issues, but again, that's another one that might be fading, simply because younger workers might have had slower access to vaccines than older workers. But I think now, with where we've got to, that's probably not so much of an issue. I mentioned that there are certain ethnic and racial groups, national groups, where uptake of the vaccine is lower, and that those statistics, I suppose, could be used to try and support a race discrimination claim in relation to trying to force through compulsory vaccination. That would be an interesting one, because the argument, I suppose, would be I am reluctant to engage with a vaccine, and more people of my race are similarly reluctant, and therefore we're adversely impacted by a policy. It's an argument, and one that I won't be surprised to see somebody trying to run. I wouldn't care to predict what the outcome of such a claim would be, but certainly there are a number of discrimination risks there to manage, and it would not be a straightforward proposition, I'm sure. If we move to the next slide, I've mentioned some of these already, but I've listed there some of the potential obstacles and objections. The other obvious one that I haven't mentioned, of course, would be a claim on disability grounds from someone with an immune system disorder, for instance, or any other of the categories of medical condition that make them ineligible for vaccination. And that would be a fairly straightforward claim, I would think. I've mentioned also pregnancy, ethical and religious concerns. Both of those ethical and religious concerns could form the basis of a religion or philosophical belief claim. So there are certainly a number of serious issues in the way of an employer forcing through any kind of compulsory vaccination policy. And if we just look at the next slide, I see I've got ahead of myself a little bit in mentioning disability, age, religion, philosophical belief, sex in pregnancy, and race as potential claims you might face. They're listed there on the slide. the potential for objective justification. I've alluded to this exercise already, but it's about identifying your legitimate aims, ensuring that the introduction of the policy would in fact meet those aims, and demonstrating that you've considered and can show that the policy, it is proportionate to impact the policy, to introduce the policy. And that's around showing that you've weighed up the impact on employees, the negative consequences of the introduction of a policy on protected groups, and have a reasonable judgment that is proportionate in light of your legitimate aims to introduce. I think, given that you're potentially juggling a number of different potential categories of claims, such as disability, age, religion, philosophical belief, that would be a complicated exercise. I certainly don't say it's impossible, but I will say it's not straightforward. And moving on to the next slide, please. Just a quick point to make about recruitment. We have been asked a number of times whether clients can ask during the recruitment process whether candidates are vaccinated. Generally, information about health is not permitted to be asked at the recruitment stage. Section 60 of the Equality Act that I've mentioned on the slide is the legislation that restricts you from doing that. And it appears to be an untested point at the moment, but generally it's thought that questions around vaccinations are likely to amount to health information that therefore breaches that section. That's likely to be something that lands you in legal difficulty if you attempted to do it. I'm just trying to keep an eye on time and allow some time for questions. So I'll leave that there and move on to the cases. The first of those on the next slide is Prosser and Community Gateway Association Limited. Sorry, I see that I've just jumped away from my notes and I see we've not quite caught up. Can we move on to the next slide, please? There we go. Okay, great. Right. So Ms. Prosser was, as it says there, a pregnant 0 hours worker who was sent home at the beginning of the COVID pandemic as she was seen to be clinically vulnerable by her employer. Her employer carried out a risk assessment and implemented social distancing measures, which delayed her return to the office. During her absence, she was paid generously in excess of her contractual entitlement, although one payment was mistakenly made late, but the tribunal found that that wasn't actually anything to do with or because of her pregnancy. On her return, Ms. Prosser was informed that her rota would not include nights or responder shifts, as such shifts involved working alone, traveling to tenants' homes alone, and physical contact with tenants. And such elements of the night shift were considered unsafe for her as a pregnant worker as a result of the risk assessment the employer carried out. And she brought claims of discrimination and victimization on pregnancy grounds, and they were dismissed by the tribunal, which held that her treatment had been appropriately informed by the available public health advice and COVID regulations at the time. So it is important to consider what public health information is available to the employer at the time it makes the decision. Now, if we move on to the next slide and look at the case of Cabelius and Kent Foods Limited. So due to the pandemic, one of Kent Foods' major customers, Tate and Lyle, required face masks to be worn by all staff at its Thames site, and visitors were issued a face mask on entry. The Kent Foods driver handbook stated that customer instruction regarding PPE must be followed, and maintaining good relationships with customers and suppliers was essential. The Kent Foods handbook also spoke about courteous treatment of clients and employees taking all reasonable steps to safeguard their own health and safety, and that of others as a result of their actions at work. So that's the context. During a delivery to the Tate and Lyle site in Thames, Mr. Cabelius refused to wear a face mask while sat in his lorry cabin with the window open. Managers at the site were concerned that he could pass the virus to other people due to his elevated position in the lorry, and 2 Tate employees requested that he put his mask on whilst in the cabin. He argued that his cabin was his home and that wearing a face mask was not a legal requirement. and he was subsequently banned from the customer's site, which materially affected his ability to do his job. So the employer investigated, and he was dismissed for gross misconduct. In refusing to comply with Tate's instructions regarding PPE, the employer found that Mr. Cabelius had breached the requirements to maintain good relationships with clients and to cooperate to ensure a safe working environment. He brought a claim for unfair dismissal, and the tribunal determined that his dismissal had been fair. And it said that the reason behind the decision included his failure to comply with the handbook, which amounted to misconduct. It felt that the disciplinary hearing had been fair. It's noted that Kent Foods business depended on maintaining good relationships with its suppliers and customers. And it noted that the employer had continued to insist he'd done nothing wrong, which caused concern as to his future conduct. And it was not feasible for him to continue in his contractual role due to him being banned from customer site. So the dismissal was upheld as fair. I mean, I think I would say that that is something of an unsurprising result. It does seem to be one of those cases that's maybe wider out on the margins. Contrast that with, if we move on to the next slide, the situation for Mr. Ham. Now, this was right at the beginning of the pandemic. It happened in March 2020. And I do suspect that the employer in this case may have taken a different approach if these things had happened maybe, say, 12 months down the line. But in this case, Mr. Ham worked for a cleaning service and was asked to collect equipment from a client and deliver it to his manager's home, while his manager and his manager's daughter were self-isolating with COVID-19 symptoms. And he queried whether this was essential and suggested that he leave the equipment with the client until a later date. And he was dismissed and brought a claim for automatic unfair dismissal on health and safety grounds. And the tribunal found that in querying the management instructions that he had been given, he had expressed concern for his and his family's health. And that engaged Section 100 of the Employment Rights Act that I mentioned earlier. And the tribunal concluded that as his dismissal was for the principal reason that he had raised health and safety concerns of an imminent concern of material danger, it was automatically unfair under that provision. If we just move to the next slide, please. And this is just to remind you what sections 44 and 100 say. So section 44 is the detriment element, and section 100 is the automatic unfair dismissal element. So hopefully that's just a quick reminder of the things that we're talking about. We move on to the next slide, please. And we have the case of Rogers and LEEDS laser cutting. So the employee here worked for the company as a laser operator in a large workspace with 5 people typically working in the space at the same time. Following the first lockdown, the company informed staff that the business would remain open and measures would be put in place to allow staff to work as normal whilst reducing social contact. That was in accordance with government guidance at the time. And the measures implemented included social distancing, wiping down of services, and staff being told not to congregate at lunch and break times. On the 29th of March 2020, after a work colleague had displayed coronavirus-like symptoms, Mr. Rogers told the company that he had no alternative but to stay off work until the lockdown eased because he was concerned about infecting his 2 young children, one of whom had sickle cell anemia and the other of which was just 7 months old. And a month after he communicated that to the company, he was dismissed. So he had less than 2 years service, so he couldn't bring an ordinary unfair dismissal claim, but he did bring claims for automatic unfair dismissal under section 100. And the tribunal accepted that he had significant concerns about the pandemic and said that was entirely understandable. They found that any belief that there were circumstances of serious and imminent danger, which is the section 100 test, could not be reasonably justified on what was known when the relevant acts took place. And as such, his automatic unfair dismissal claim was dismissed. And coming to that conclusion, the tribunal particularly noted that despite his concerns around COVID-19 expressed to the company, he actually drove his friend to the hospital the day after he informed the company he intended to stay off work. And this was during the period he'd been told by the NHS to self-isolate. And in addition, on his own evidence, it wasn't difficult at that employer's workplace to socially distance given its large size, which was described as the size of half a football pitch, and the small number of employees who were there at the time. So the tribunal concluded that a belief of serious and imminent danger could not be reasonably justified. So I think that demonstrates the limits of Section 100 automatic unfair dismissal cases and Section 44 detriment cases. It's a relatively high threshold to show a reasonable belief in a serious and imminent danger. We move on to the next slide. This is the case of Acatatis, I will say, and for Tuna Group. The claimant in this case worked for a company which sells and distributes PPE. In March and April 2020, his request to work from home and be placed on furlough due to feeling uncomfortable around using public transport and working in the office were denied due to the nature of his work, which was not possible to do from home, and the needs of the business for him to continue doing it. And he was told he could take paid holiday or unpaid leave if he wished to stay at home. He declined, and after further requests to be furloughed, he was dismissed. He didn't have the requisite 2-year service, so again, he pursued an automatic unfair dismissal claim under Section 100. And the tribunal found that although there were circumstances of danger which an employee could reasonably have believed to be serious and imminent, Mr. Akatatis' demands to work from home or be furloughed were not appropriate steps to take to protect himself from danger. And again, this has to be viewed in the context of it taking place in March and April of 2020. The tribunal determined that the employer was justified in concluding that he could not work from home and did not qualify for the furlough scheme. There was the option to take holiday or unpaid leave available to him, which he declined. So his claim was dismissed. And finally, we have a case of Montanaro LandSafe on the last slide. I think here the slide largely speaks for itself. So Mr. Montanaro was on holiday in Italy when the country went into lockdown. He sought advice from LandSafe and sought instructions and assistance with documentation, took steps to work remotely. The employer didn't provide any of the advice, instructions, or assistance he asked for, and instead summarily terminated his employment. And the tribunal held that his communications were clear, where there are clear circumstances of danger, he'd been dismissed because he communicated the difficulties posed by the pandemic, and that did meet the threshold of Section 100 of a reasonable belief in serious and imminent danger. So a relatively quick spin through about half a dozen cases, some of them dealing with that issue about reasonable belief in serious and imminent danger, others around masks and other COVID issues. I hope you found that interesting at least. I see we've got quite a few questions in the Q&A. I haven't actually had any look at them yet. So
you want me to put them to you, Bob? Would that help?
Yeah, that would be great. Thanks, Nick.
So first of all, we've had an anonymized question. I'm obviously not an employment lawyer and haven't studied it, but this sounds like it would be an employment law exam question. We might need to caveat it with not giving specific legal advice as well. But what would your advice be regarding a BAME asthmatic social worker who's refusing to undertake home visits or leave their home? They've had 3 jabs, the issue being that they can't satisfy their contractual or statutory duties regarding vulnerable families with home visits and things like that. Could it be considered a disciplinary matter?
So the social workers had both vaccination jabs and the booster. They're refusing to undertake home visits or leave home. And there are capability and attendance issues circulating in the background. I mean, I think I would say it largely depends on the specific circumstances of the employee's medical condition. So how bad is this asthma? what medical information do you have about his exposure to risk? I certainly wouldn't want to start to engage in any kind of disciplinary process, for instance, until I'd obtained reliable medical information. I'd want to know what the employee's specific justifications are for his position around not wishing to carry out home visits, and I'd want to explore what measures are currently in place to minimize risk to all employees who undertake home visits, and what, if any, measures could be undertaken in this employee-specific situation to try to reduce risk. And that might include obvious things like instructions to those he's visiting to wear face masks there to visit, to what extent home visits can be carried out in ventilated spaces at a social distance. You know, you'd want to engage in the risk management process and the employee's specific concerns. But I can certainly see a situation here where you could go through a proper process of engaging with the concerns and reasonably conclude that they're not justified, have also communicated both general and specific risk mitigation things that you've done around the home visits, and have the employee still be refusing, and you be therefore be in a relatively safe position. And by safe, I mean able to justify a disciplinary process that ultimately could take you to a dismissal, a fair dismissal, and also be able to demonstrate that it is not on account of the employee's protected characteristics, and that you have accommodated your duty to make reasonable adjustments. So I can see a way through all of that if the dice fall in the right way, but you've got to engage with the concerns and engage with what can be done to alleviate them and increase mitigation or reduce risk, whichever way around you want to put it. Yeah, that was an exam question. Thank you. If the person who's asked that anonymously would like to have a bit of more of a discussion about it, by all means, I think my contact details are provided on the slides. By all means, get in touch with me and we can discuss it in a bit more detail.
Great, thanks, Bob. Another question then. If an employee refuses to come to work because of their belief that there is serious and imminent danger on public transport, what are an employer's obligation? Do they have to let the employee work from home in any industry? I don't know whether that's sort of dealt with by Rogers and LEEDS laser cutting about whether it's a genuine concern.
Yeah, I mean, I'd say the short answer is no. They don't have to let an employee with that objection automatic work from home or face an automatic unfair dismissal claim under Section 100. Bear in mind that Section 100 requires a reasonable belief in a serious and imminent danger to health. I think the position we have reached now is quite an interesting one, where just a day or two ago, I was reading an article by an NHS clinician who said that in hospitals, COVID has become essentially a disease of the unvaccinated, and that there's very few, it's a very small number of people occupying hospital beds with COVID have been double vaccinated. And that, I think, is relevant to the question of to what extent a fear of catching COVID represents a reasonable fear of serious and imminent danger. I'm not saying it doesn't, but I think that the landscape has changed slightly to where we were before vaccinations were taken up by such a large proportion of the population. But if you're an employer faced with an employee making these statements, what you will want to do is engage with what options are open to them to travel to your workspace, what can be done to mitigate risks whilst using public transport. Obvious things around that might include shifting their working times so that they don't have to travel at peak hours, for instance, exploring with the employee the possibilities of phased returns so that they're only doing a certain number of days, mitigating the risk in that way. Again, you've got to engage with it, but I don't think that an employer is going to automatically be facing unfair dismissal claims simply because an employee says, I'm scared of traveling on public transport and I'm not coming in. That is not a position I think you have to simply accept.
But it's you just need to go through the right sort of steps of engaging.
As is the case with about 95% of risk management in employment law. It's the process, isn't it? Process and engagement. That's what it's all about.
Okay, a slightly different tack with this next one. Rather than employees not wanting to come in, what about employers who want to continue with home working, but the employee wishes to return to the office? So it might be they're looking to reduce their, the amount of space they're taking, the like. Especially if the contract states the place of work as the office. Can the employer force a change of contract terms?
Well, forcing a change of contract terms, ultimately, if you're not going to get the employee's agreement to vary the change of contract terms, then you're going to have to go through what various of the trades unions and the elements of the media are calling the infamous hire and refire approach, which of course has been a method of enforcing contractual variations for some years, and does require employers to have a legitimate business reason for the variation and to go through a consultation process. And if they don't have a sufficiently good business reason, although the tribunals don't tend to second guess business reasons too much, if their business reason is not a legitimate business reason, or if they don't follow a proper process, then that dismissal will be an unfair one. So I'm afraid the answer to that question is it depends. And what it depends on is why you want your employee to stay away from the office. But ultimately, if your business reason is good enough, there is an option to vary that is open to you.
Great. Okay.
Sorry, Nick. I should also say you might want to be thinking about indirect discrimination risks as well. So you're also going to probably want to do some kind of impact assessment around what are your legitimate aims, what's the impact, and are you making sure it's proportionate?
Great. If we have staff with family abroad and we have flexible working, what are the issues with them going on holiday and then working overseas for a while? Would it be reasonable to put the onus on them to sort out any visa requirements?
First of all, I will say that employees working abroad generally is an enormous can of worms. So working abroad for a short period while on holiday is probably the least risky part of the continuum. And at the other end of it, I've had clients who, for instance, unknown to them, had an employee who was working from home during the pandemic in Finland and had a child whilst in Finland and accrued 2 lots of maternity pay, Finnish and UK statutory maternity pay.
Wow.
So working abroad can open up a whole host of unknown risks. So not knowing what social security benefits and entitlements the employee accrues as the result of being based there, what statutory rights they accrue by virtue of working in a different jurisdiction, dual tax issues, data transfer if it's outside, transfer outside of the jurisdiction, whether it's safe for data transfer purposes. It is more difficult to comply with your health and safety duty to ensure a safe place of work. I could go on. So generally speaking, I'm not a fan of allowing employees to work abroad. I do think that a small bit of working on holiday is probably the one potentially justifiable exception to that rule. The question just says working overseas for a while, so the duration of that working overseas is going to be quite important. If we're talking a number of months, I'd start to get concerned about it. And of course, it will depend on the location as well. Unfortunately, having a flat policy of not allowing employees to work abroad also raises issues, because you can see a relatively straightforward argument that it might be indirectly discriminatory of non-UK citizens who would find it harder to comply with the policy to be based in the UK while they're working than someone who's from here, due to visa requirements and those kinds of things. that's not insurmountable. All that requires, again, is a proper impact assessment. All of those difficulties that I've just listed are reasons why you will have easily identifiable legitimate aims in avoiding employees working abroad. And then it's just a matter of considering the impact of your policy and the proportionality of your approach, which largely involves saying, is there a less impactful way we can achieve these aims? And if you can reasonably say no, then you should be all right. So and finally, the question says, would it be reasonable to put this onus on them to sort out any visas required? Well, if the reason for them working abroad is simply because they want to add an extension onto their overseas holiday, I'm not sure it's necessarily for me to say whether it's reasonable or not, but I can certainly see the argument to say, well, that's up to you then, because you're the one, we have no requirement for you to be based there. But I'd start from saying, I'm not sure that it's a good idea to agree to any significant period of overseas working without thinking through the full ramifications of what that might be. One other thing, that if your employee has the ability to enter into contractual arrangements on behalf of your organization, then them working abroad and doing that could amount to you creating a permanent establishment in that jurisdiction, and that's a whole other host of legal and regulatory obligations. So be careful.
Wow, I had no idea the potential impact was so wide-ranging.
Yeah,
Maybe I won't be asking for a week of working abroad either side of a holiday. Just
yeah. Well, I mean, I think if you're tagging on a few days to holiday, you can take a view on whether there's any material risks there. But if it's a significant period, be careful.
Right. We're just at 3 o'clock, but we've got one final question, which I hope will sort of be relatively swift, which is, what would the position be in relation to stress and COVID and absence? So I guess it's sort of COVID-related stress and absence. Does that need to be thought about differently?
In short, I think yes. I think that could be very much a complicating factor that you would be required to engage with. I mean, the question is put in such broad terms that it's difficult to say anything other than you're going to need to engage with the issue of the employee's stress as well as them having COVID. If it's just stress caused by fear of COVID, that could be a mental impairment with a substantial long-term adverse effect on ability to carry out day-to-day activities, i.e. a disability. It might not be. How you manage the employee is going to very much depend on the specific circumstances. Again, I'd probably, as an initial point, want some kind of medical advice, occupational health, for instance, around the impact of the employee's conditions and how you can engage with them. I think that's about all I can say, given that the question's put in general terms. But again, if the person who's asked it would like a more detailed chat, by all means give me a call. I'd be happy to discuss it with them.